Yeah, here we are coming to CMA final paper number 16, direct taxation. We are going to start with the study note 1. Okay, understood? We are going to start with the study note 1. So this study note 1 is all about assessment of various entities. Okay, in that first entity we are going to say is company. Okay, company which is defined under section 270. Okay, which is company which is defined in the section 217. Okay, we are going to read about it. And actually basic provisions we have all read, we have finished all those things regarding basic provisions and everything. So we are going to apply all the provisions, the basic rate and surcharges, margin relief, then extra, the like special rates, everything we have read separately, but how to apply to that particular company or to that trust or to certain type of business trust. Okay, investment funds, how we are going to apply that is this chapter is all about. Okay, here we are going to read about first company. Here in income tax, what do you mean by company? That's a question over here. Okay, in income tax, what do you mean by a company? So that is defined in section 217. Okay, so as far as company is concerned, there are two type of companies as far income tax is concerned. One is domestic company, that is defined in section 2 subsection 22A, and the other one is a foreign company, that is defined in section subsection 2 section 2 subsection 23A. Understood? Here in this, okay, what are we are going to discuss? Just we are going to see in detail everything. Okay, what do you mean by company? As far as income tax is concerned, company is defined in section 217, which means an Indian company. Okay, and body corporate or incorporated on any other foreign laws. Okay, foreign companies act will be there, no, apart from Indian companies act. This Indian company is company which is incorporated as per Indian companies act. Okay, and this foreign body corporate is incorporated outside the country, that is by law by foreign countries, we call them as a foreign companies. And any institutions or association or body which are accessible and they become assessee in the name of company. Okay, so as like saying it is a company in the name of company, they become assessee, then they be called as a company. And one more provision is there, one more point is there. What is that? See, that is, if CBDT, Central Board of Direct Tax is there, no, if we declaring through special orders or general orders that this is a company, it has to be assessed. Okay, it has to be assessed as like a company. Okay, okay, that have you are you clear about point D? So CBDT, Central Board of Direct Tax, will be declaring some association or some institution, whether incorporated or not, whether it is incorporated in Indian or non-Indian, under any laws, non-Indian laws or Indian laws. But without incorporation itself, it can declare, has a power to declare some through a special or general orders as a company. Understood? This is are you clear about section 2 subsection 70? Next we are going to study about what do you mean by Indian company. Okay, Indian company is company which means and registered under Companies Act 1956 and include all formation, registration, any form of company formally in force. So before this 1956 and after this 1956 2013 and everything, they be forming and registering under the Companies Act, which has a statute in India. Okay, the company formed and registered any law for time being in force in state of Jammu and Kashmir, and any company or registered any law for time being enforced in Union territories. Okay, Union territories, so they know Goa, then Pondicherry, everywhere they be Union territories will be there. Their Companies Act won't be applicable, but some other laws will be there. Because of that laws, under that law, they be forming a company. Okay, and any corporation established by or under a central state or provisional act. Okay, and any institution or a body which is declared here also, that CBDT will be declaring some special through special orders and everything, that this is a company. Okay, this is an Indian company they be defining. Okay, so those all come under preview of Indian company. What do you mean by domestic company? Said that actually there's a much difference between domestic company and Indian company. So the domestic companies include Indian companies or any company with respect of which income liable to tax. For example, one company is not incorporated in India. It is not incorporated under the Companies Act 1956, but it is incorporated under the foreign laws. But that particular company is liable to tax under this act has been prescribed arrangement for declaration and payment of dividends. Okay, that particular company has arranged to pay dividends and declare dividends payable of such amount of income within India. They are paying dividend where? Within India. Okay, so that is one specific ruling regarding this. That is rule number 27 for declaring and payment of dividend. What the rule number 27 says is that a company be made by a company, arrangement for to be made by a company for declaring and payment of dividend, including dividend of preference shareholders within India, and a separate register has to be maintained by the company for all the shareholders, okay, including preference shares and everything, in the principal place of business in India. And the general meeting, second point is general meeting for passing that particular in the relevant previous year, that dividend will be declared, okay, and that be held only in where? In India, and the dividend so declared should be payable within India to all the shareholders. So this was a case. Even if a foreign company is making arrangement to do all this dividend declaration payment and in the place of principal place of this year, that became a domestic company. So that's the difference between Indian company and a domestic company. All Indian company or domestic company, apart from that, something is being specially added, that is declaring dividends in India. Okay, and in the place they have a principal place of business in India, and they are declaring dividend in India, and they are conducting a meeting for declaration of that particular dividend, and they are payable in India. Those companies we call it as domestic company. Understood? Then next one is foreign company. Here, foreign company which is not a domestic company, which all not will not form under this domestic company. There is two subsection 22A which not fall over there. All others will be falling over in the 223A. So it is not a domestic company. That is the main point. Okay, foreign company means which is not a domestic company. Understood? Then we are going to company in which public are substantially interested. This is 218. Okay, so we call them some companies or which in which publics are interested in it. Okay, so what those companies is all about means government company. Okay, government company which is holding for not less than 40% of shares together either with the governments or RBIs. Okay, that company we call it as government company. And next company is a section 8 company, which is a non-profit organization. Okay, non-profit organization can be formed as in the form of company, provided their objectives are approved, okay, in that particular ROC, and they be formed under section 8. Okay, that company is also the company in which publics are not substantially interested. Understood? Understood. Then we are going for one more company, that is mutual benefit finance company. So this is a different type of company which is formed under Companies Act 1956, and their business, it is based on their principal business. If their principal business is accepting deposit from members, so they be having solid number of members, and they be accepting deposit from the members, and they which is declared by central government. Actually, as per section 620A of Companies Act 1956, a company named Nidhi company or mutual benefit company is defined, and which is specifically will be declared by central government. This is a Nidhi company, this is a mutual benefit company. Okay, understood? Next comes company in which shares are held by cooperative society. A company whose equity shares are carried on less than 50% voting rights has been allocated unconditionally to or acquired unconditionally by or through 11 previous year, be beneficially held by one or more cooperatives. So their shareholdings, how much percentage? Above 50%. Okay, not less than 50%. So it is above 50%. If voting power is left within one or more cooperative society, we call them as a company in which shares are held by cooperative society. Understood? Next company is listed company. Listed company means in which equity shares of that particular company in the relevant previous year is listed in a recognized stock exchange in India, where the recognized stock exchange in India is Mumbai. Okay. And next point is if the equity shares in the company carrying on 50% when it comes to 50% of voting rights, okay, unconditionally or acquiring unconditionally by through any of the government or corporation established by central or state. Okay, so if it is a government company, we have seen the definition of government company, right? Like that sort, if any 50% of that particular shares voting rights is with whom, either with the government or with a corporation that is established by central and state provision act, or any company to which the above it is a subsidiary of this company. Okay, a listing company, one company is a subsidiary of one more listing company means then that company is also will be categorized as listing company only. For example, A Limited is there. A Limited is a listed company. That A Limited 50% above shares are holded by a one more company. Or A Limited is holding B Limited shares above 50%. What will happen? Automatically, B will be also a listed company. Understood? These are the three categories. This 40% means when 50% means when it comes to normal companies. But when considered about industrial companies, that is manufacturing, processing, construction of ships, generator and distribution of electricity, or any other form of powers. Okay, industrial companies means 40% of Indian companies constitution voting power is enough. If 40% of that particular Indian companies shares voting power is held by government or a corporation, it is established by central state presidency or any of the subsidiaries which is wholly owned subsidiary. We call them as wholly owned subsidiary for that particular holding company. That holding company is a listed company means the subsidiary company will also be a listed company. So it will be parent, we call them as a parent company like that sort. Okay, holding company, we call them as a parent company like that sort. If you are this holding company, then it will be. So that holding, then we have to consider for the relevant previous year. Okay, we have to consider for the relevant previous year only. Understood? And we are moving to company which is prescribed by board. Okay. So company which is prescribed by board, the company having no share capital. Okay, it doesn't have a share capital. Okay, some companies will be formed without having a share capital. It'll be company by guarantee like that sort. Okay, it have regards to its objective, the nature and composition of membership and other relevant consideration. It should be declared by the board. So board means over you whom the CBDT will be declaring it is a substantial interest company. It is a deemed to be a company like this. So they'll be declaring and they will be calling them as a deemed company, and it will be assessed in the category of company for that particular assessment year. Okay, and they will be declared as a company. Okay, and see company, if a company is an assessee, what all rates applicable? Okay, that is here when come to capital gains. Okay, we are having short-term capital gains and long-term capital gains. As you know, we have having a short-term capital gain that is defined under 111A, and we are having a long-term capital gain that is taxed differently at 112A, that is 10% and 15%, and other long-term capital gain. Normally, some capital gains are charged with 20%, and the categories which is coming under 112A it is charged with 10%, and the short-term capital gain, the shares and everything, that is 111A, that will come in 15%. Okay, this is all applicable. And apart from that, if you have any income from other sources on the head winning from lottery, okay, lottery, crossword puzzle and everything, normally how much is the percentage? 30 is a percentage. Okay, not only for companies, all others it is applicable. So if you are having any lottery incomes and everything, that tax rate is how much? 30%. Understood? And when it comes to domestic company, we have seen what is domestic company, right? So in this domestic company, we have to see one particular thing. What does that mean? If your domestic company's turnover in the previous year, which previous year? 2018-19, if it is exceed 400 crores, then that rate of tax will be 25% on net taxable total income. Okay, understood? That is 25% on net taxable total income. If you're not crossing that 400 means it is 25 percentage, but if you're crossing 400 means it is 30 percentage. Understood? And when it comes to foreign company, see, we have seen the definition of foreign company, which is not a domestic company. In this domestic company, Indian company will come, and also other companies who are declaring dividend in India, and they having a share of a general meeting in India, and they are having payment or made in India means that time. Okay, dividend payments are made in India means that time that company will be considered as a domestic company. For that also these provisions will be applicable. Okay, this rate will be applicable. Then which all company will not come under the purview of domestic company means that is a foreign company. Okay, so foreign company royalty received from there are two rates for the foreign companies. Okay, one is royalty amount. So Indian government or Indian concerns are giving royalty to that particular company, to the particular foreign company means that time the rate is 50%. Understood? Understood. And such agreement has to be either approved by the central government. So central government has to approve that particular royalty agreement. And if they are approving and they are paying any royalty income from the government or an Indian concern means which is approved by the central government means that time the rate of income tax will be 50% on the royalty income, only on the royalty income. Understood? Whatever royalty income they are paying out of the government is paying or any other concern, Indian concern, on approval central government they are paying means that is 50% on that royalty income. But any other income, okay, any other income, then it is 40%. Understood? These are the tax rate for companies and categories. Okay. And we are coming to the surcharge. Already we have seen n number of times what is surcharge, how it is applicable and everything. So we are going to see in companies precipitative. Okay, so amount of tax computed. So you be computing some tax based on that 40% or 50% on royalty, 40% for foreign company, and 25% of for domestic company. And if it's exceed 400 crores of turnover in 18-19, it will be 30%. Like that's all you be calculating. First step you be calculating net total income. Okay. First step you be calculating net taxable total income. On the total income you be applying the rate of income tax. Okay. Okay, so you be applying, so you be finding out the income tax payable. Okay, in that you have to add surcharge. Okay, when surcharge will be applicable? When surcharge will be applicable? If the income, okay, if the income it is less than or equal to 1 crore, then for this domestic company it is nil. If your income is less than 1 crore, if your income is domestic income or a domestic company income or a foreign company income, both the companies, whatever companies may be, if your income, that particular company's income is less than 1 crore means there is no surcharge. But it exceeds 1 crore but is below 10 crores means for domestic companies 7%. 7% means on what? On income tax. Okay, you be calculating one income tax over here, no, on that income tax. On that income tax you have to apply this percentage, 7 for domestic company and 2 for a foreign company. Okay, if you are exceeding 10 crores, if your company's income is exceeding 10 crores, then rate of surcharge is 12% and 5%. Understood? And you'll be calculating some surcharge and based on the percentages. Okay, then we be having a tax with surcharge on that. So tax after surcharge. Okay, tax liability after surcharge. Okay, so here after tax liability after surcharge you be applying cess. This always applicable to every assessee. Or like the thought here also it is applicable to the company also. At what the percentage? What's the percentage of cess? It is 4%. Okay, 4% on this amount. Okay, add cess. Cess how much? 4% on this amount. Understood? Understood. So marginal relief. Apart from this, we are having marginal relief for individuals and everything. Same way, we are here also that marginal relief is there. Okay, condition the total income of that particular company has to exceed 1 crore. And relief, what's the marginal relief is? Ensure that additional income tax payable, including surcharge on that excess income over and above 1 crore is limited to the amount by which income is more than 1 crore. Okay. Similarly, relief is also available if income tax exceeds 10 crores and in above 1 crore, the replacement will be there. So here I'll be teaching how to calculate the marginal relief. Right. Actually, this marginal relief is calculated as per section 89. One second.